Welcome everyone. My name is Tony Gleeson. I'm the Chief Executive Officer for AIRAH. And today I'm welcoming you from the Wurundjeri, people of the Wurundjeri tribe, from the people of the Kulin Nation. And I want to pay my respects to those elders, past, present and emerging. Today, particularly, is important for AIRAH as we're a recognised accredited provider for the Queensland Professional Engineers Scheme. And this has certainly been a milestone for AIRAH to be able to see that our industry, the HVAC and R industry, more specific, the mechanical engineers that work in here, can use their work, continuing professional development, and also to be assessed by our fellow members in terms of being accredited. So it's very important that a step for AIRAH, but more importantly now this webinar is to give people an opportunity to be able to ask some questions, but more importantly hear from the Queensland Professional Board of Engineers. We're very lucky today to have two people to join us. One is Mathew Cuskelly, who's the Senior Principal Legal Officer for the BPEQ, as well as Nathaniel Tunney, who's the Communications and Engagement Manager for BPEQ. And today, please take some time and to use the Q&A function to ask questions, engage, and also to be able to just help you clarify where you sit in this process and what's available for you. So I'd now like to hand over to Nathaniel. And Nathaniel, thank you again for being part of today's session.
Thank you very much, Tony, and good morning, everybody. As Tony mentioned, my name is Nathaniel Tunney. I'm the board's Communications and Engagement Manager. We thought it would be timely to sit down with AIRAH members and speak a bit about the Professional Engineers Act and the process of registration, given that AIRAH has recently been approved as an assessment entity for BPEQ. So what we're going to do today is present on the legislation, the Professional Engineers Act, which is the legislation that governs the work of engineers working in or for Queensland, and then talk about the process of becoming a registered professional engineer of Queensland, or RPEQ for short, and that's a more common term that is used. Mathew Cuskelly, who's the board's senior principal legal officer, will speak about the legislation and the key components of that, and then I will take on the presentation to speak a little bit about the registration process. Happy to answer the questions you had today, keeping in mind that the board, as the regulator for the profession, isn't there to provide legal advice. So you'll forgive us if we have to steer clear of certain questions, because that is getting into the realm of providing legal advice. So things like, is this a professional engineering service, for instance? We can't answer that. That would be giving legal advice that the board isn't allowed to do under the functions set in the Act. So we'll start with a brief introduction to the board. Established way back in 1930, so it's a well-established system that we have for the registration of engineers here in Queensland. The impetus for that was some events happening overseas around the time of the Great Depression, where governments were trying to stimulate jobs and economic activity, and there was a couple of engineering incidents where shoddy engineering work was one of the reasons for certain things happening. So Professor Roger Hawken, who was the Dean of Engineering at UQ, saw what was happening overseas and advocated for a scheme of registration here in Queensland to uphold engineering standards and make sure professional engineers were qualified, competent and experienced enough to do what is very complex work. So we've had this scheme in place for 90 years now. It is a comprehensive and mandatory scheme in Queensland covering any and all areas of engineering. There is no industry-specific exemptions. If you're an engineer working in or for Queensland, providing professional engineering services, you must be registered, clear and simple. There are a couple of exemptions there that Mathew will discuss, but by and large, this is just part and parcel of what engineers should be doing as they progress in their career, getting registered and compliant with this legislation. So that's the board in a nutshell, the legislation. At this point, I'm going to hand over to Mathew, who's going to take us through those key concepts in the legislation.
Okay, use these ones. Good morning, everyone. Thanks very much for the introduction. My name's Mathew Cuskelly. I'm the Senior Principal Legal Officer with the Board of Professional Engineers. So my role is to provide legal advice for the board. And I have a staff of senior lawyers and investigators. And essentially, the predominant part of our role is to administer the Act with regard to mutual recognition registrations and compliance of disciplinary related offences. So the first slide there, is there some way of being able to clear that? Bear with us for a moment. Okay. So as you can see there on the first slide, the BPEQ is established under the Professional Engineers Act. That's the main statutory instrument that we administer. There's also regulations to the Act. Key objectives of the Act are to protect the public by ensuring professional engineering service is provided by an RPEQ in a professional and competent way to maintain public confidence in the standard of services provided by RPEQs and to uphold the practice of RPEQs, and the way that is achieved is through registration, and as I said a few moments ago, there's disciplinary measures that the board can take following the investigation, which is conducted by myself or one of the team here, or prosecutions again following an investigation conducted by myself or one of my colleagues. So that's just a brief overview of the statutory instrument, relevant statutory instrument, and some of the compliance and disciplinary functions under the Act, which are designed to obviously maintain public confidence and ensuring that professional engineering services are being provided in a competent way. So, as no doubt most of you, if not all of you, would already be aware that the RPEQ framework is unique to Queensland. There are now other jurisdictions implementing similar frameworks, but up until relatively recently, Queensland was leading the engineering profession by providing a framework for registration. And as Nate mentioned, the BPEQ organisation has been around since the 1930s, as I understand. Consequently, there are RPEQs spread across Australia. Again, the law requires under the Professional Engineers Act that if you're providing a professional engineering service for Queensland, that you're required to be registered. There are some issues around extension of the Act's jurisdiction, but I won't go into those complexities at the moment unless somebody asks me a question along those lines. But generally speaking, and for simplicity's sake, the jurisdiction as far as this organisation is concerned will only really extend to matters involving Queensland. That doesn't mean that we won't look at matters outside of Queensland, but that will be more along the lines of when an RPEQ is practicing in another state and is delivering a service into Queensland. As that slide details, only qualified and competent persons who have gained registration can carry out professional engineering services. It is an offence in Queensland not to. So if you're somebody who's engaging in a professional engineering service and they're not registered, then it is actually it's an offence under section 115 of the Act. The penalty there is 1,000 penalty units, which is it's $100 or $110 per penalty unit. So the maximum penalty for practicing in professional engineering services, when you're not authorised, justified, or excused by law to do so, is around the $100,000 mark. So there's no industry-specific exemption. An engineer may not provide services direct to the public, but must still comply with the PE Act. The PE Act applies to professional engineering services in Queensland and for Queensland. So again, from a jurisdictional perspective, as far as the occupation is concerned, this organisation as the regulator will really only concern itself with that last particular point there on that slide. So what is a professional engineering service? Well, the definition is provided in Schedule 1 of the Act, and there's a number of elements there. You can see, so it's an engineering service, requires or is based on the application of engineering principles and data to a design, to a construction, production, operational, maintenance activity relating to engineering. We got a lot of feedback, and there is a lot of discussion around the ambiguity of the Act. Well, that's why there's lawyers, so that you can retain a lawyer, so that the lawyer can conduct the research and provide you with the advice around what is not an engineering service. But the issue seems to come up with a level of regularity around qualifying exactly what is and what is not an engineering service. Well, there is the definition that the Act provides us, and it's then assessed on a case-by-case basis. Direct supervision is an exemption to being registered as an RPEQ. Basically, in short, this requires that if you aren't registered as an RPEQ, then you need to work with somebody directly who ultimately takes responsibility for the final end product, who is registered as an RPEQ in the area of engineering that is relevant to the final produced product. As the slide says there, a person who is not registered may carry out professional engineering services only under direct supervision of an RPEQ is responsible for the services. Some of the relevant or salient issues to consider with regard to the issue of direct supervision is that it needs to be direct contact, actual knowledge, direction, oversight, evaluation, and as I said before, that RPEQ needs to take full responsibility for the final end product. Again, this comes up regularly with different geographical locations. Can I be supervised remotely? Well, that's something that ultimately you would need to get legal advice on, and it's a case-by-case assessment as to whether sufficient supervision has been engaged. Ultimately, one of the other tools that we can refer to is the explanatory notes to this Act, and that essentially tells us that if a professional engineering service is being provided in, say, for example, a Townsville office, then the supervising RPEQ must also be located in the Townsville office. An exemption would be if the professional engineering service is being advertised as being produced from, say, the Brisbane office, where the supervising RPEQ is located, then that may ameliorate the situation. But if there is any assertion or contending that the professional engineering service is being provided, say, from the Townsville office, where the non-registered person is located, and the RPEQ is not located, well, then that would be, by way of example, hypothetically, a clear breach of the requirement for direct supervision. Long and the short of it, and to keep it simple, if professional engineering service is being provided in one office, then ideally another supervising RPEQ should be located in the same office, who is authorised under the same area of engineering that is required for the end product, and who ultimately takes responsibility for that end product. Next slide. So this is an example of direct supervision in practice. And this is what I was referencing a few moments ago. Sometimes you'll get an RPEQ that will delegate to non-RPEQs and works conducted. In this situation, it's clearly the RPEQ is too removed, too distant from the from involvement. The RPEQ is required to be proximate to the work, to the output, and to be taking final responsibility for the end product. And as you can see there, notwithstanding all those points, none of the evidence demonstrated that the above had occurred in relation to the professional engineering services, the subject of the case. No records demonstrating that supervision had occurred. So, look, again, this is another often hot topic. What evidence is sufficient? Well, again, you'd need to get legal advice on that, but common sense prevails at the end of the day. Emails, diary notes, file notes, that sort of stuff that will independently corroborate that there has been another party involved in the matter and has been actively engaged, in control, evaluating, assessing, etc., the information, and ultimately taking responsibility for the final end product. There is a practice note on the BPEQ website in relation to direct supervision, and I would encourage all of you, if it is relevant, well, irrespective of whether it's relevant or not, to read that practice note. And when in doubt, always seek legal advice. Next slide. So what makes a prescriptive standard? A prescriptive standard is an exemption to the practice of a professional engineering service. So the Act invokes jurisdiction over those that are practicing and delivering professional engineering services, not matters that are of a prescriptive standard. So essentially a checklist. Again, there is somewhat of a definition as to what a prescriptive standard is, but my advice is that if you've got doubt, get legal advice, because ultimately ignorance of the law is not a defence to ultimate liability under the law. So that's why lawyers exist, so that you can retain them, get their opinion regarding the application of a piece of legislation, and that way you'll at least have some level of guarantee moving forward. So, as it's detailed there, it's a document. It states the procedural criteria for carrying out a design, a construction activity relating to engineering. The document explains how to apply those procedures and criteria to a particular task to which the document relates. The application of the procedures or criteria stated in the document must not require advanced scientifically based calculations. The service is carried out only in accordance with the standard. Okay, so really, and look, there may be circumstances where there is what appears, in essence, prescriptive standard, but it might be argued that it is actually engaging a professional engineering service. So, look, it's always best to get advice. It's a good risk management, corporate governance strategy to have in place to get advice before you start doing any sort of project or activity that involves the possibility of engaging a professional engineering service, because this is legislation, and just like you've got traffic law, you've got criminal law, you've got the Drugs Misuse Act, you've got all sorts of different pieces of legislation that has to be complied with. So disciplinary and compliance are the two aspects of the Act that the unit that I oversee and lead administer. Disciplinary matters relate to RPQs and allegations of unsocial professional conduct. Compliance-related matters relate to offence provisions under the Act, so namely criminal offences. By way of example, as I said before, not practising or practising when not registered as an RPEQ is a breach of Section 115 of the Act, which is a criminal offence. So grounds for disciplinary action against an RPEQ. So they've behaved in a way that constitutes unsatisfactory professional conduct. There is also a code of practice. I'd encourage you to go and have a look at that. The engineer has failed to comply with the provision of this Act or the Repealed Act. They've been convicted of an offence against an act of the state, the Commonwealth, another state related to the practice of engineering. The engineer has contravened an undertaking entered into by the engineer and the board under section 73(2)(b) of the Act. The engineer has contravened a condition of the engineer's registration. So they're grounds for disciplinary action under the Act. And as I said before, allegations of a disciplinary breach will be investigated by the Legal Compliance Investigations Unit here at the Board of Professional Engineers in Queensland. So it might be myself that investigates that, or one of my colleagues. But as I said, our unit comprises lawyers and investigators, and we will invariably undertake 95% plus of this of the investigative and litigation work that is created as a result of administering the Act. So we just discussed a few moments ago the Act's definition of what is unsatisfactory professional conduct. Again, this is also contained within the Act. Conduct is of a lesser standard than that which might reasonably be expected of a registered professional engineer by the public or engineers' professional peers. Conduct that demonstrates the competence or lack of adequate skill, knowledge, judgment, or care in the practice of engineering. Misconduct in professional respect. Fraudulent or dishonest behaviour in the practice of engineering, or other improper or unethical conduct might all qualify as unprofessional or unsatisfactory professional conduct. So it's fairly broad. So there's an overview of a disciplinary intake. We received the complaint. Bill can also instigate investigations on their own motion. Goes to investigation. We conduct there's an investigator appointer. As I said, that might be myself or one of my colleagues. Matters investigated, we take statements, we appoint experts, or an expert, and we go about just gathering evidence and compiling what's referred to as a brief. And that's ultimately what we look at to determine, make a decision and provide advice to the board on whether there is sufficient evidence to take action under the Act, which relates to these options here. So disciplinary matters commenced in the Queensland Civil and Administrative Tribunal, also referred to as QCAT. And there are these other options here, ultimate members of the board. So the board can recommend an undertaking, caution or reprimand, impose registration conditions, or take no further action, in addition to commencing disciplinary, rather than commencing disciplinary proceedings in QCAT. And if successful in QCAT, which is very similar to a court for those who don't know what a tribunal is or not had any experience with one, it runs very similar to a court. These are the options available to QCAT, which again are listed within the Act. So the Act is the empowering or enabling legislation, not only for this board, but also for the QCAT if we were to invariably end up there. So these are the criminal offences that I was mentioning a few moments ago. With respect to the Act, Section 113, 114, 115, there are others, but these are the main ones that relate to practising in professional engineering service or delivering a professional engineering service in Queensland or for Queensland when you're not registered pursuant to the requirements of the Act. As I said before, maximum penalty for any of these offences is 1,000 penalty units, with one penalty unit being worth $100. So you're looking at around $100,000 per offence as a maximum penalty. Ultimately, if you have the misfortune to have to defend one of these matters, your legal representative is charged with the responsibility of trying to make submissions to reduce that maximum penalty that can be applied by the court. And compliance matters go to the Magistrates Court, which, as far as we're concerned, will be filed in the Brisbane Magistrates Court. There's an overview of the intake process, decision to investigate, investigation, post-investigation, ultimately commencement of proceedings by way of complaint and summons in the Magistrates Court, if the board makes a decision to do so. Same process as the disciplinary intake. In fact, it's exactly the same, except for the disciplinary matters, they go to Queensland Civil and Administrative Tribunal. Compliance or criminal matters go to the Magistrates Court. Okay, so if you're convicted, you can potentially have a conviction recorded and be subject to one of those significant financial penalties that I mentioned, and also have a cost order made against you. So it can be quite significant. Okay, risks and penalties of not being registered. Greater financial penalties, maximum penalty, prosecution of unregistered person, 1,000 penalty units. Whereas the maximum penalty for RPEQ in a disciplinary proceeding is 200 penalty units. So you've got 100,000 versus 20,000. Professional engineering service not done or directly supervised by RPEQs is illegal work, and payment not enforceable. Okay, there's a case there of AIRAH. So basically, in this situation where you contract to deliver a professional engineering service, where you're in breach of the law, you've breached the statutory requirement to be registered, and the Act specifically exempts the other party from having to pay you. So contract law is, without becoming too technical, but if you engage on a contractual basis with another party, it's governed by contract law. Well, the Professional Engineers Act creates jurisdiction over that relationship in circumstances where the individual is delivering professional engineering service within the jurisdiction of the Act and is not registered. So it can be quite significant. Last point there, unregistered engineers are limited in the scope of work they can perform. They risk contravening the Act, even if there is nothing deficient with the product or service. So again, it's critical to be registered, and we have to keep in mind the ultimate objectives of the Act, which is to protect the public, ensure that practitioners are doing the right thing, and people ultimately have confidence in the industry and profession. That's my presentation complete. What I will do is I'll hand you now over to my colleague, Nate, and he can outline to you some of the details regarding registration and otherwise becoming an RPEQ. Thanks very much, everyone.
Thank you, Matt. So now that we understand the key concepts in the Act, direct supervision, professional engineering services, prescriptive standards, etc., we'll turn now to the process of becoming an RPEQ. It's a 4-stage process. Now, the first thing you need is a degree in engineering. That must be a recognised engineering degree of 4 years to a Washington Accord standard. The Washington Accord standard, for those that don't know, is the international benchmark for engineering degrees. Australia is a signatory to the Washington Accord. Therefore, any engineering degree from an Australian university, with that, you will have met the requirement to meet stage 1. The next thing is competency. So that can only be gained through working in the field as an engineer. The board wants to see that the applicant has got the theoretical knowledge of engineering and then is using that in a practical sense. So 4 to 5 years post-graduation is what the board expects an engineer to have done first, to then proceed to the next stage of the registration journey, which is assessment. During the assessment process, one of the board's approved assessment entities, of which AIRAH is now one, will be looking at the qualification and competencies of the applicant. The processes between the assessment schemes differ. As AIRAH members here today, you're going to be best served by having a chat to AIRAH about the processes that you will go through there to be registered in mechanical engineering. But as part of the assessment, you should be able to demonstrate that you're a qualified, competent, and experienced engineer, and should be eligible to call yourself an RPEQ and carry out professional engineering services to a very high standard as per the Professional Engineers Act and Code of Practice for engineers that we have. The assessment schemes are listed here. Again, I'll point to AIRAH being one of our most recent schemes. The assessment schemes undertake assessments in different areas of engineering. Now, you don't have to be a member of the entities that are listed here to go for an assessment. They are obligated to provide assessments for both their members as well as any non-members. If you've got some voluntary accreditation through one of these organisations, you can use that potentially to demonstrate your eligibility for registration, because to get that voluntary accreditation, you would have had to demonstrate that you're a competent professional engineer and gone through an assessment of sorts. So the board will take an assessment that you've done to get that voluntary accreditation to meet the competence standards for registration. But keep in mind that the voluntary accreditations that any of these entities may offer aren't the same as RPEQ. It's not registration. It can just be something that you use to demonstrate your eligibility for registration. The final stage is applying to the board formally to become an RPEQ. So that's when you'll submit evidence of your assessment. So as part of the assessment process, you'll be given a letter of eligibility or a letter of assessment. And then you bring that to the board along with a formal application form, meeting certain criteria in that form in terms of fitness to practice along the lines of any criminal convictions, financial matters, health matters, things like that, that the board needs to be aware of. That's your fitness to practice. You'll nominate the area of engineering you want to be registered in. So for somebody coming through the AIRAH process, they'll be saying, register me in mechanical. And if all that goes according to the plan with the board, they're satisfied that everything is as it should be, you will be registered and able to call yourself an RPEQ, which is a legally protected title that must first be earned by going through this registration journey. For interest's sake, the areas of engineering are listed here. You'll notice that there's very well-known areas of engineering like your civil, mechanical, electrical, structural, and then there's some more specialist areas as well. Ordinarily, you'll register just in a single area of engineering that pertains to your competence. But say in your career as it progresses and you develop further competencies, perhaps gain some specialist knowledge in one of these more specialist areas of engineering, you might choose to add an additional area of engineering to your registered status. Now, to add an area of engineering, you can't just simply put it on your renewal form for registration, and the board will accept that. You will need to go through another assessment to demonstrate competence in that additional area and then apply anew to get that recognised. So maintaining registration. I said before that you must renew your registration. Now, to renew your registration, which is an annual requirement, you must comply with the Code of Practice for engineers. Key to that, one of the key elements is working within your area of engineering. So if you're registered in mechanical, making sure you only practice within the mechanical field. You can't go out there and start providing electrical engineering services or civil engineering services unless you're registered in those additional areas. Within area of engineering, there's also area of competence. So I'll use civil as an example because it's a very broad discipline of engineering. Within that, there's various subsets and specialities. So you might be great at doing designs on a viaduct or a bridge or a thing, something like that, but not necessarily adept at the design of a dam or some other form of the built environment. There are differences in the competencies that civil engineers possess. So again, you must only practice within your area of competence. And this comes down to, in many respects, a bit of personal judgment. You need to understand where your limitations begin and end when it comes to your competence within your area of registration. I equate it to a bit like having your driver's license. That's your registration, but you may not be comfortable driving a four-wheel drive up in far north Queensland, which comes down to competence and experience. So that's why you must make that personal judgment to only practice within your area of competence, which falls under your overall area of engineering. Renewing your registration is an annual requirement between 1 April and 31 May. That's the renewal period every year. That doesn't change. And during the renewal period, you must complete a renewal form, which includes things like the fitness of practice declaration and questions, whether there's been any matters that have happened in the intervening year that the board should be aware of in terms of your registration elsewhere, or indeed your membership of one of the professional bodies. Now, if you don't renew your registration by the 31 May cutoff, your registration will likely lapse. There is a bit of leeway to have it restored if there's a reason why you didn't renew it in time. But if you know that you're going to be taking a break from the profession, a good option is to renew your registration, but set it to non-practicing. I think of this as putting your registration in standby mode. You don't need registration necessarily because you're not providing professional engineering services, but you could return to engineering in the future. So therefore, non-practicing allows you to keep your registered status, and you can activate that to practicing even when you return to the workforce. CPD is a very, very important ongoing registration requirement. For RPEQs, they must do 150 hours of CPD over a 3-year period. If you break it down, it becomes a lot more palatable, I guess. It's 1 hour a week. And the way that you can get CPD is diverse. Today's seminar, for instance, if this is furthering your knowledge and understanding in some way in a non-technical respect, you can claim it as CPD. AIRAH puts on learning and development opportunities for its members. You might attend a conference, you might present at that conference, that's CPD. Even an element of private learning through reading technical journals and things like that is CPD. On-the-job training, also CPD. It's anything that's furthering your knowledge and understanding of engineering. Very, very important to record the CPD that you do because it will be audited by the board. And indeed, as part of the renewal form, there are questions about whether you've done the adequate number of CPD hours. So make sure you're recording it because you will be called upon to provide evidence of CPD every now and then. It must be technical, and that will be the bulk of your CPD hours, how it relates to your area of engineering. But also there's the expectation that there's some non-technical things that you do, like today's seminar, but you might do things like risk management, project management, things like that that are of a non-technical nature. So that's for practicing RPEQs. For the non-practicing RPEQs, the CPD obligations are still there, but they are reduced a little bit. It's 150 hours over a 5-year period or prorated for whatever period of time you were non-practicing for. If you've got more than one area of engineering, then you don't have to do 150 hours per area of engineering. It's still 150 total, but just making sure you balance it to those areas of engineering that you are registered in. So complying with the Act. We find that a lot of people tie themselves up in knots about trying to understand professional engineering services, direct supervision, prescriptive standards, without just looking at this in a really, really simple way. If they're employed by an organisation or indeed working for themselves for their skills, experience and expertise as an engineer, assume you're going to be providing professional engineering services and get registered, assuming you've got that qualification and competence and can demonstrate that. Make it very, very simple for yourself and treat this as just a step on the journey in your career. Keep professional records of engineering decisions and to demonstrate direct supervision. As was discussed in that case, the downfall of the offender there was that they didn't keep adequate records of direct supervision. Always renew your registration during the renewal period and complete and record your 150 hours of CPD. Only practice in your area of engineering and within your competence. And finally, if asked to sign off or certify something as an RPEQ, be clear about what that means, because there's nothing in the Professional Engineers Act that explains, identifies, defines what RPEQ sign-off certification is. It's something that has developed organically out there in the industry and could mean any number of things. So if you're requiring it or indeed giving an RPEQ sign-off certification, be clear with all the parties involved what that is going to mean for your purposes, because there's nothing in the Professional Engineers Act that provides any guidance there. That brings us to the formal conclusion of the talk today. I see there are a couple of questions coming through, and if we can answer them, we will.
Yeah, Nathaniel, I might jump in here. So there was an early question on, and it might be if Mathew's still around, from Jaswant about how does direct supervision work on maintenance of an engineered process?
How does direct supervision work with the maintenance of an engineered process?
Yeah.
Well, I guess it would work the exact same way as any other engineering activity. The RPEQ would have to be involved from start to finish in the maintenance or activity, in providing the evaluation, direction, and oversight of that service, and they would take full professional responsibility for it. It wouldn't really change in terms of the elements that would need to be proven for that direct supervision exemption to be used, be it a maintenance service or a design service. It would just be the RPEQ is involved there in a transactional relationship with the non-RPEQ, providing that adequate evaluation, direction, oversight of the work, and taking full professional responsibility for it. Mathew, did you want to build on that any further?
No, look, if it's a professional engineering service as defined by the Act, then the RPEQ needs to be involved, or there needs to be to the RPEQ being involved, which is the direct supervision. So again, I refer you to the practice note on direct supervision, and otherwise obtain legal advice.
Not a problem. Just also, I think this was Mathew as well, but Ross is, there was a slide on prescriptive standards, but he didn't notice if there was a suggestion that a person following a prescriptive standard did not need to be RPEQ. Is preparing a design in accordance with a prescriptive standard still a professional engineering service?
Well, a prescriptive standard is not a professional engineering service. So it's going to the schedule of the Act. So prescriptive standards means a document that states procedures or criteria for carrying out a design or construction, production, operational, maintenance activity relating to engineering, and the application of which carrying out of the design or construction, production, operational, maintenance activity does not require advanced scientifically based calculations. So if it doesn't require that advanced scientifically based calculations, the chances is that it isn't a professional engineering service, and you should be okay. But again, I caveat that with the fact that I can't provide legal advice, and it's a good governance process to have in place with organisations to get their own independent legal advice so that they can rely on that. I'm just giving general advice well, I'm just having general discussion. So in short, from what you've described to me, no, that would not, on the face of it, would not qualify as a professional engineering service. However, it always comes down to a case-by-case situation.
So seek legal advice if you're in doubt.
Absolutely.
Yeah.
If there's any element of doubt, seek legal advice. That's why lawyers exist for, so that they can provide you with advice, and then you've got some level of security.
Yeah, not a problem. Okay, just a follow-up question as well, and this might be a bit of a history lesson, but what was the reason behind the Washington Accord degree being acceptable? This is more from our industry's point of view, where mechanical engineering degrees barely have any relevance to HVAC and R building services, when there were previous degrees out there that were run in Australia, which don't quite meet the Washington Accord. Is there a specific reason why that was embedded back in 2002 in the Act?
Look, Brendan, I'll be honest, I don't have the answer for that here and now. I'd have to go back and do a little bit of research myself. What I would think it would come down to is the fact that in 2002, when the Act was substantively amended, and there were only a select number of assessment entities, those organisations that were brought on as assessment entities, and moving into that co-regulatory model between the board and the assessment entities, that they needed to put in place a threshold, and they settled on the Washington Accord as the threshold in concert between the board, the assessment entities, and Parliament. But I would have to go back and do a little bit of digging myself.
Yeah, okay. I might follow up that one with you, Nathaniel, and I'll be able to respond to Ross separately on that. So that sort of answers, I think, the next question about how much input did Engineers Australia have in on the scheme. If they were one of the original assessment entities, I'm assuming there was some guidance and direction from them being involved early on.
Could well have been. It's going back a fair number of years now, and look, I think I'm 100% confident that nobody was here at the board now was around back then, in 2002 through to 2008, when the Act was amended and all the registration assessment entities were first introduced. Look, I think looking at it practically, though, they would have been a stakeholder in the process. How much of a say they had, hard to say. And look, I'd have to do some serious digging to work out what stakeholder engagement went on way back then. I'm not sure if I'd be able to uncover that sort of information. Sorry.
No, that's fine. So the next question from Ross, which I'll have a stab at, regarding what is the point of AIRAH providing a similar pathway to Engineers Australia, and not providing alternative pathways. Ross, obviously we have to be accredited by the BPEQ. We had to set up a scheme to register our members to the state requirements. We have been advocating with not just the Queensland government, the New South Wales and Victoria about alternative pathways, but our scheme to be accepted as an accreditation body needed to meet the requirements set under the Engineering Professional Engineers Act. And Ross, I'm obviously happy, or Tony's probably happy to discuss that further with you. A question from Andrew Ling. Many professionals working in building physics and Section J. This is using engineering data to provide design guidance or specifications, therefore could be seen to fall under the PE Act. However, it is not covered as an area of engineering. can you shed some light on how such work would be considered with respect to the Professional Engineering Act, and how would a mechanical engineer pursue RPEQ in that area?
Look, I think that's one of those questions that we, as the regulator, just can't touch on, telling you what is and is not a professional engineering service. But in terms of a mechanical engineer working in that particular area getting registered, well, they would just have to, first of all, have that degree in mechanical engineering, have their experience, 4 to 5 years post-graduation, and then be assessed as a qualified competent engineer for registration to get registered. That doesn't change. As for telling you about that particular example, as I say, I think that's getting into the realm of saying, offering a judgment on what is and is not a professional engineering service, which BPEQ simply cannot do.
Yeah. So what's in terms of, just a follow up from just once early about the direct supervision work on maintenance of an engineered process, he just made a comment, but that doesn't really happen for the maintenance of fire services or smoke control designs or indoor air quality for buildings. So it's really just a follow up statement from just once. So there's a question from Dario, whether you can touch this or not. In New South Wales, the equivalent PE Act applies to building elements. Is it the same with the Queensland Act? For example, the refrigeration plant inside a supermarket is not considered a building element in New South Wales. What about Queensland?
We're currently looking at the other schemes of registration, and with regard to, let's see. So to answer your question as to whether we can answer it, in short, no, we can't, because we haven't received the advice on that issue at this particular point in time. So in short, I don't have the advice and I don't have the instructions from the board on the issue.
Yep, not a problem. And I know that's something, Dario, separately that we've approached, not just the Queensland board, but the others around that refrigeration engineering sector, because it does seem to be a bit of an a weird space. Then there's some, yes, it needs to be a degree. No, if you don't do certain things, it doesn't. So we're trying to get some clarity around that as well. A question from Chris Salmon. Do the deemed to satisfy provisions of the BCA form a prescriptive standard, and hence producing a design that was only deemed to satisfy not a performance solution would not be professional engineering services? That might be seek legal advice, but happy to hear you guys.
Can I have the question again, Brendan?
Yeah, sure. So do the deemed to satisfy provisions of the building code form a prescriptive standard, and hence producing a design that was only deemed to satisfy would not be considered a professional engineering solution? I'd need to look at the specifics of it, and I mean that is actually specific advice. Yeah. So that's not something that I would even touch, because I haven't actually had that matter come past me in the time that I've been with the board related to that type of scenario. So I wouldn't want to venture into that realm. As I said before, a lot of this is just there's a lot of confusion and frustration from people because they get concerned about the definitions that are used in the Act and the application of the Act. As I've said before and during our discussion, if you've got any hesitation or concern, you need to speak to a legal representative who's acting on your behalf and who can advise you accordingly.
the definitions around what is a prescriptive standard and what is a professional engineering service is outlined within the Act. However, there's all sorts of nuances that arise in each individual scenario that might give place a different context on a situation. So my apologies for the vagueness in my answer, but ultimately I think we're going into the realm of legal advice there. So I'd be hesitant to commit without specific information.
Yep. Thanks, Mathew. And the last question is really one for AIRAH. Look, Chris, it is something, as I mentioned with Ross, that it is something we're trying to discuss with the various state authorities, because as you're well aware that our members have had a different education pathway. It is not set out that you go to university and do a 4-year HVAC and R degree. It is a subset of mechanical, and there were previous qualifications, but they're communications that we need to now have with the various states around that. We are advocating for our members. There is a lot of frustration out there. We are very happy to be accredited now in Queensland to meet what they require, but we will continue to discuss and liaise with them about some of our industry's concerns. I see Tony's joined us too, and he might have some further comments on that. But I might hand over to Tony to do sort of a bit of a wrap up as there's no more questions, and you might be able to, Tony, add some further information about what AIRAH's journey is going to look like.
Well, firstly, thank you, Nathaniel and Mathew, for being involved today. This has been very informative, a lot of good questions with a lot of good answers. The second thing is this will be recorded and made available on our website. One thing, this is a journey that we're going through. I think everyone, whether it's the government or whether it's our own members, and AIRAH's committed to that journey. We have written to the Queensland Minister, Mick de Brenny, just to raise the question of, people who don't have maybe only have a 2-year degree and subsequently diploma, but 40 years of experience. In fact, in some cases, some of these members actually are head of Australian standards committees, actually sit and give recommendation to the National Construction Code. But I think it's a journey. There's no one quick answer. And just to keep members informed, we're part of that journey. We're ongoing in that space. We're actively engaged with the Victorian government, and we're very close to getting recognition there. The New South Wales government is a little bit slower in terms of allocating providers or accreditors, but just yesterday we provided feedback into their process. And the WA government, we've had a number of discussions with them, and their registration doesn't start till somewhere about mid-2023. But it's what I say, it's part of the debate. It's part of informing both sides, our members as well as government, and AIRAH's committed to the long haul in this. But I think it's positive that we've been able to get the recognition for our members who actually have the qualifications and have the experience, and those that don't fit necessarily into the current situation. It's about having that ongoing dialogue with government departments and a variety of people. So I just want to say that AIRAH's in for the long haul. AIRAH's in for here to have those ongoing discussions, but we're about professionalism and commitment to the industry and engaging and discussing these issues. So I want to thank Nathaniel and again Mathew for time today, also Marie and Brendan for in their involvement. And this will be this webcast will be up on our website, and we'll be sharing it through our networks. Again, thank you very much everyone for joining today, and have a good afternoon. And if I don't get to talk to any of you between now and the end of the year, have a good Christmas break, and I'm sure we'll be engaging on the other side of the year. All right then. Thank you, everyone. Bye for now.